Well, there's a reason attorneys spend an extra 3 years in law school. The law can be really confusing, and most of us don't want or need to know the ins and the outs of it. But there are some basic principles we can all use to our advantage. Colorado's best attorney, Phil Harding, is here this morning. You always have such great advice when it comes to the legal system for us. And recently you were talking about the jury system and a lot of things that jury members don't know.
Exactly. You know, I started going over that a couple weeks ago. And, you know, there's things that people that are in jurors never know as they're trying cases and as they're looking at them. And I talked to people afterwards and they said, you never really got into the meat of this, so we want to know more of this information.
We want more, all right. And before we go on, I just want to remind everybody why you are our legal expert. He's been voted one of the top 100 trial lawyers in Colorado now for the 6th year in a row. That's not easy to do.
Yeah,
how did that even happen? You're nominated, right?
I don't know what their selection process is. If it was, I probably would be in earlier. You know,
all right, you're also an AV-rated attorney. What does that mean?
Well, you know, Martindale-Hubbell rates attorneys, and their highest ranking is AV. So I'm pleased to have that.
Way to go. That's why he's Colorado's best attorney. All right, so we've talked about the jury system, and they want more meat. So what are you going to give us today?
Well, I'm going to go into more about what jurors don't know. And we have a graphic about this, so let's talk a little bit about this. First of all, if there is a trial, and you're wondering, gee, what's going on? Why am I sitting here going over this? And I've got to tell you, if there's a trial, the parties have already tried to settle the case.
Okay.
There's a rule, Colorado Rules of Evidence 408, that says any settlement negotiations are totally inadmissible. And also, if you see the defense, if you see that the defense has an attorney, there is insurance there. But if anyone mentions the word insurance, it's instantly a mistrial.
Really? You can't even utter the word insurance in the trial?
If you talk about it, then you bet there's going to be a mistrial.
Wow.
And so they have to start all over again. Now, the other thing that I want people to know and to go into it, the judge has already excluded evidence.
And I don't understand that. Why can any evidence be excluded? That doesn't seem fair.
Well, we're going to go into a jury instruction that's going to talk a little bit about it. But for example, you may hear the words during a trial, and these words may have been, the defense admits liability. We admit liability, ladies and gentlemen. It's all about the money. And that's wrong. Usually when you hear the word they've admitted liability, it means that the person that caused this injury either had a DUI, was committing a crime, something like that. So listen to these key words. It's so important, but when they say we've admitted liability, it means you can't even bring in any evidence about how the accident occurred. You're only going to be talking about how much someone is injured. Okay,
so but as a jury member, if you hear the attorneys say you've admitted liability, then that should go off. That should be your red flag that, okay, some evidence is not going to be brought up.
Well, all throughout trials, evidence is excluded. And, you know, we have another graphic that I want to go into about when someone is hurt. And this is a jury instruction. And I got to tell you, no one has rarely seen, unless you've been on a jury, seen these jury instructions. And I've got to tell you, usually there are about 30 or so different jury instructions. And at the top, there's going to be a blank about jury instruction number blank, and it'll be handwritten in there.
Yeah.
And what it's going to say is there's about 30, so they'll be hand numbered like 1 through 30. And for example, this one, look on the bottom one, it says, you must not be influenced by sympathy, bias, or prejudice for or against any party in this case. And that's why our legislature has essentially said, hey, I got to tell you, there are things excluded. Number one, if the guy was drunk that caused this, then you would have a prejudice against that defendant.
Okay.
So that's why that's excluded. If there's any settlement negotiations, then, and let's say before they were talking about settling this for maybe $50,000, if you knew that, that would alter your thinking on what to award an individual. You know, also, if the plaintiff had been hurt before, that's some big things that need to go on as well. So these jury instructions really lead people into conclusions and leads them into the right conclusions. You know, the important thing is when you put 6 people together for state, 12 for federal, and they get their minds together, they don't miss anything. And I got to tell you, they know that there's insurance. They know that the guy was drunk. Even though it may be excluded, you put these 6 collective people together from all walks of life.
They read between the lines?
They read between the lines and they know it. But there are some things that jurors never get, and when I talk to them afterwards, there are these caps. There are caps on lawsuits and on damages and so forth. And it is unbelievable. And I want to tell you some of these. You know, like the McDonald's hot coffee case, remember she got $3 million? After the jury walked out, because of these caps, she got less than 75% of that. There was a 75% haircut on that. And here are some of these caps. For example, the most anyone can suffer is $436,000. I don't care if you've lost all of your children or whatever.
So even if they said you get 10 million, your max for pain and suffering is $436,000.
$436, $70. That's right.
What is the point then? I just don't even get why they would say you can get 10 million when you really can only get 436. Why even put it out there?
Well, you know, and I totally disagree with some of these things, and but I'm a plaintiff's attorney, and absolutely.
I mean, just as a jury member, I'd want to know that.
There are other things that go on, and so not only is there the pain and suffering, there's also on punitive damages, and there was the graphic up there. Even though someone may award $20 million in punitive damages, you can really only get 1 times the compensatory damages.
Incredible. All right, good stuff. Always, it's so fun to have you on. We learn a lot about the legal system, and no matter what you're dealing with legally, Phil can help you out. If you have a question for him, just go to our website, coloradosbest.tv. Use his picture. You can click on it and send your questions right to him. He will answer it personally for you. And if you'd like to contact Phil at his office, Harding & Associates, here's the number: 303-762-9500. You can also go online to hlaw.org.